So, good morning, everyone, and please join me in welcoming Advocate Aayush Agarwala, a counsel practicing in the Supreme Court of India, where he is registered as an advocate on record. He is also a partner at PBA Legal LLP, a premier law firm based in Delhi. Ayush holds a bachelor's degree in financial and investment analysis from the University of Delhi and was an avid noter while studying law at Campus Law Center. Pursuant to his enrollment in 2012, he initially worked as a judicial clerk in the High Court of Delhi and subsequently in the chambers of a senior advocate practicing in the Supreme Court of India before a brief break to pursue a master's degree at the University of Cambridge with a specialization in commercial law. As a small housekeeping request, please may the audience mute their speaker phones during the discussion and turn off the video mode. We would like you to ask questions by placing them in the chat box. While we may not be able to take all the questions, some of these questions can be addressed during the Q&A session. The topic for today's discussion is to decode the offense of insider trading in India. Many will admonish the strange choice of words, for if insider trading is an offense, it should require an active prosecution of the accused before a court of law. But we often see SEBI levy penalties. So it all begins with a certain type of information in the company called unpublished price-sensitive information, or let's just call it UPSI for short. Now, UPSI is information related to the company's securities that is generally not available to the public. It's a secret, But this information is not just any information about the company's shares, for example. It is that information that can materially affect the price of the company's securities. It's that information which sends ripples in the market, and we see shareholders either eagerly selling off their shares on hearing that information or potential of future shareholders purchasing the shares of the company. UPSI is the polar opposite of generally available information and is defined under Regulation 2, Subregulation 1E of the SEBI Prohibition of Insider Trading Regulations 2015. That's long, isn't it? So let's just call it SEBI PITR, sorry. I repeat that, SEBI PITR is the short form. Some examples of UPSI include financial results, such as the company's balance sheet or profit and loss statement, which informs investors on whether the company has made a profit or a loss. Now, if the company has made a profit, the shareholder wants to hold on to the shares of the company. Why do you think that is? That is because the shareholder will want to take a form of the dividends, right? The profits form a part of the dividends, and what does the shareholder want? The shareholder wants the dividends. And that's an incentive for the shareholder to hold on to the shares of the company. This is the reason why financial statements like balance sheets and the profit and loss statement are price sensitive information, because that is something that the shareholders look at while deciding whether to stick on with the company or leave it. Other forms of UPSI include mergers, demergers, and other such business transactions, or it also includes change in key managerial positions of the company. Now, it could be when a seasoned business leader that has garnered market trust leaves the company. The departure could send shockwaves in the market and affect the price of the company's securities. This is why the key managerial position is so crucial, and somebody leaving a key managerial position is price sensitive information. The question is, who will have access or possession to UPSI in a company? Many will say, oh, it's obvious, isn't it? It's the company's directors or those working in the financial department. And wait, hold on, did you consider the managers working closely with the directors? That's right. The top management and directorship of the company is likely to be privy to this information. And so begins the task of identifying who will have access or be in possession to this UPSI. The result of this task is envisaged in the definition of an insider in the SEBI PITR. Insiders are persons who are either connected to the company or who have access or possession to this UPSI. Now, under the category of connected persons, there are two subparts. First, those persons who 6 months prior to this impugned act of insider trading or dealing in the company's securities were able to gain access or possession to the company's UPSI. This also includes persons who allow access or possession of the UPSI. So, for example, a stockbroker getting access to UPSI from the company's director is a connected person for the purpose of SEBI PITR and hence an insider. The second subpart has a predefined group of persons or entities that are deemed to be insiders, such as immediate relatives of a connected person, a member on the board of trustees in a mutual fund, or an official of a stock exchange. However, when we are talking about this predefined category, there is a rebuttable presumption. And so this rebuttable presumption is in the second subpart, where the persons mentioned can prove they were not connected to the company whose securities are subject to insider trading or dealings. The concern is it seemingly places a reverse onus of proof on the identification of this identified person, which means the person is presumed to be connected to the company and the burden is on such a person to prove they were not connected. Now that we know who the insiders are, the question is, what is trading? The term trading too has been defined, and it has been defined under Regulation 2, Subregulation 1L, SEBI PITR, as an inclusionary term. It means and includes the act or agreements to subscribe, buy, sell, or deal in any securities. So, dealing includes form of, let's say, pledging shares, for an example. Therefore, the category of persons identified as insiders when they, for example, buy and sell in the company's securities when in possession of the company's UPSI is insider trading. All right, so what's the problem with this? The problem is that insider trading is prohibited in India under Section 12A, Subpart D of the SEBI Act. There is also a prohibition under Section 12AE of the SEBI Act on dealing in securities when in possession of UPSI or communicating UPSI to another person to enable illegal dealing in securities. The trading and communication prohibitions with their accompanying exceptions are further detailed in SEBI PITR, particularly Regulations 3 and 4. Okay, so we know we shouldn't be engaging in insider trading because the law says that's wrong. But hey, there must be some underlying rationale behind it, right? Otherwise, the law is arbitrary if it doesn't resolve a problem or have a purpose. So what is so bad about insider trading? A good example to glean the underlying rationale for a prohibition on insider trading is the case of Rakesh Agarwala versus SEBI, where the Securities Appellate Tribunal quoted Lord Lane while he was referring to a white paper on the conduct of company directors. Lord Lane observed that an insider could be tempted to take advantage of UPSI before this UPSI comes into the public domain. For example, the insider may commence purchasing the securities of the company based on UPSI at a lower price. And when this information becomes public, what do you think that insider does? The insider sells off the company's securities at a higher price, thereby making a profit. Such a trade could also lead to a rise in the price of the company's securities. As such, the insider gains an unfair secret advantage. The reason for making insider trading illegal is to maintain public confidence. That is, this unfair secret advantage made by the insider because of their proximity or position in the company is something that the law does not tolerate. Insider trading also appears similar to cheating since confidential information is used to make a profit by a few to the disadvantage of the others, particularly those in the public. All right, now that makes sense. So, what happens when an insider engages in insider trading? This question brings us to the theme of today's session. Is insider trading an offense or something else? A simple answer is yes. Insider trading is a crime if the elements of the crime are met. There are two provisions relevant to insider trading in India. The first is Section 15G SEBI Act, that is a penalty provision. It provides if an insider deals in securities based on UPSI of a listed body corporate or communicates UPSI to any person except as required by law or except in the ordinary course of the company's business or say counsels or procures UPSI is liable to a penalty. The penalty is a sum between 10 lakhs to 25 crores or it could be 3 times the profit made from insider trading, whichever is higher. Now please note, there is no imprisonment for insider trading under Section 15G. With a provision which is pretty much in the nature of a penalty. So, a penalty applies if there is a mere breach or non-compliance with a provision of a legislation or a regulation. There is no requirement of a court proceeding to levy the penalty, and such a power to levy penalties is often given to quasi-judicial bodies or administrative bodies like SEBI or the Income Tax Office. Now, a penalty is different from an offense. Under Section 24 SEBI Act, if a person engages in insider trading contravening the provisions of the SEBI Act or its accompanying rules, in particular Section 12A, D, and E, because these are the provisions most relevant to insider trading, that person shall be punishable with imprisonment for a term that extends to 10 years or a maximum fine of 25 crores or both. So most importantly, Section 24 commences with the words without prejudice to any award of a penalty. So most likely this phrase could be perceived in the nature of a non-obstante clause, perhaps to mean that an action under Section 24 can commence notwithstanding any award or penalty under Section 15G. And if one notices the heading of Section 24, it is titled Offences and most importantly includes imprisonment. To understand the difference between an offence and a penalty, let us consider the judgment in Cement Distributors Private Limited versus Inspecting Assistant Commissioner Central, Range 2 and others with a citation 1973-87 ITR 163 Madras, delivered by the High Court of Madras. Now the court notes the term penalty is a slippery word, and needs to be understood in the context of a given statute. The word penal here encapsulates civil liabilities which do not constitute an offence against the state. And the important point here is it is not an offence against the state. For instance, a breach of a statutory duty or something which is subject matter of a complaint could simply be a penalty. It's a simple disregard of strict statutory provisions. It's like saying, okay, you did not adhere to the black letters of the law, now pay up for non-compliance. In essence, a penalty lacks the mens rea element of prosecution launched before a criminal court. This is the reason why SEBI can levy penalties for non-compliance of The SEBI Act and SEBI PITR, hence to say Section 15G, contains the consequences of a civil offence would not be correct. We can't use the word offence for Section 15G because offence has a different meaning. It is in the nature of a crime, and for that, we need to have that mens rea element. It's not simply non-adherence to the strict black letters of the law. So we can't use the term offence for Section 15G. We can call it a penalty. Hence, the term civil offence for Section 15G is not correct, or is not seemingly correct. The court in cement distributors goes further to note that sometimes the term offence has been loosely used for subject matter which is not a crime, or which could only be dealt with criminal courts, such as misdemeanor while filing income tax returns. Now, misdemeanor is sometimes referred to as an offence. Now, this too may not be right, because Article 20 of the Indian Constitution specifically refers to an offence in terms of a conviction for violation of the law. In that, a person cannot be convicted for an offence except in violation of the law. Such a conviction is handed down by criminal courts with a threshold of proof embedded in beyond a reasonable doubt. The criminal courts will assess the material or evidence before them. There's going to be a proper trial happening. Now, the evidence is tendered strictly in accordance with the Evidence Act. Now, drawing an analogy with Section 24, one notes for insider trading to be a criminal offence, SEBI will need to prosecute an accused before a criminal court and prove beyond a reasonable doubt that the accused intended to commit the crime, if we're going by what cement distributors had to say. I'm drawing an analogy from there. So the threshold is that, look, the person intended to trade when in possession of UPSI with the purpose of gaining an unfair advantage. Now, SEBI cannot imprison someone on its own because it's not a criminal court. It has the power of a civil court for the purpose of gathering information or conducting inquiries. Where is this coming from? It's coming from Section 11, subsection 3 of the SEBI Act. It also has the power to give directions or levy a penalty under Section 11B of the SEBI Act. But does it have the power to function like a criminal court? The answer is not really. SEBI cannot declare someone guilty of insider trading, but SEBI can prosecute someone for insider trading before an Indian criminal court. Further, SEBI has administrative and regulatory functions. Now, here a parallel can be drawn with income tax authorities that have similar administrative function but cannot exercise their jurisdiction as a criminal court. And the statement in Ranavira versus Vikramasinghe, the citation is 1970 AC 951 PC, and I quote from this judgment that for a body to exercise quasi-judicial functions in order to reach an administrative decision does not convert that body, be it the commissioner, into a judicial officer within the meaning of the Constitution. This statement has persuasive value when considering SEBI's role, that is regulatory or investigative in nature. But the nature of the role does not make SEBI a criminal court or empower its officers to determine the guilt of an accused like a criminal court. Moving further, the court says in this case of cement distributors that a plain meaning is attributable to the word offense. Take it as you read it. Open a dictionary and try and understand what the dictionary meaning of the word offense is. And that's the meaning that we should be going with. So this plain meaning is attributable to the word offense, where the trial must be before criminal courts. Therefore, we have seen SEBI consider penalties in a number of cases, like Jubilant Stock Holdings Private Limited versus SEBI Appeal number 174 of 2018. Another case is Mr. D. Bala Reddy versus SEBI Appeal number 509 of 2015, and VK Call versus SEBI, which is a part of the Company Law 2 syllabus for this semester. The citation is 2012-116 SCL 24. So we've got civil penalty um, cases that have come before SEBI, and SEBI has given an adjudication order, for example. But there are very few celebrated cases of insider trading as a criminal offense, since the threshold of proof is supposed to be beyond a reasonable doubt, and the element of mens rea needs to be proved. So this is the reason why you might not see SEBI very proactively going after someone under Section 24. Rather, SEBI would prefer to look or consider the matter under Section 15G of the SEBI Act. Now, in this case of Rakesh Agarwal, SEBI sought to initiate prosecution under Section 24 SEBI Act along with adjudication proceedings under Section 15G of the SEBI Act against Rakesh Agarwal, who was the managing director of ABS India Limited. Now, a notable observation from the case is that both Section 15G proceedings for imposing a penalty for insider trading or dealing in securities when in possession of UPSI. So we've got Section 15G there, which SEBI is pursuing. We've also seen SEBI in this case pursue Section 24 for criminal action that was sought to be taken against Rakesh Agarwal. Now, why are we discussing Rakesh Agarwal? Is because on the element of mens rea, the Securities Appellate Tribunal questioned whether insider trading could be an offense merely because an insider deals in securities based in UPSI but receives no personal advantage. The intention or motive of insider trading becomes material for the objective of prohibiting insider trading to be achieved. The SEBI regulations do not explicitly mention mens rea as an element of insider trading. The Securities Appellate Tribunal subsequently referred to the case of the state of Maharashtra versus Mayor Hans George. The citation for this case, AIR 1956 722 AT PG 728, where it said that when a statute was silent on the element of mens rea, there were two aspects that must be kept in mind. First, the purpose of the statute, and second, a rebuttable presumption in common law that mens rea was an important element of a statutory offense, although this presumption could be set aside due to the words or the subject matter of the statute. The language of Section 24 was considered by the SAT, that's the Securities Appellate Tribunal, to assess whether mens rea was a part of insider trading as an offense. It was noted that persons violating the SEBI Act faced criminal prosecution through imprisonment or a fine or both. The objective of insider trading was to prohibit an insider from gaining an unfair advantage, and if the person alleged to have committed insider trading had no intention of gaining an unfair advantage, insider trading as an offense could not be made out. With this, the Securities Appellate Tribunal noted that intention or mens rea was an element of insider trading, and if action was brought under Section 24, mens rea had to be proved. Now, in this case, applying this legal principles, let's see what was the factual scenario or the factual matrix. Rakesh Agarwal had commenced discussions with buyer or bear, whichever way you would like to pronounce it. You've got two different pronunciations there. There could be many more. Was interested in sharing its expertise or for sharing technical expertise in resin or polymer industry. Now, while Bayer was interested in sharing its expertise on resin and polymer, As per its worldwide policy, any joint venture with Bayer would require Bayer to have 51% shares in the joint venture company. That is, 51% shareholding in ABS India Limited. Now, it is true that Rakesh Agarwal was an insider as the managing director of ABS. Now, why does SAT say this? Because he was well informed of Bayer's interest to substantially acquire shares in ABS. He was the one who was initiating the discussions, and due to his position, it could be concluded that he had access to the information on this particular transaction. Now, Rakesh Agarwal had instructed his brother in law while the information on this transaction had not become public. And the name of his brother in law was Mr. I.P. Kedia. And Rakesh Agarwal had asked Mr. I.P. Kedia to purchase shares of the company. Which company? ABS, the company that he was working for. But the court observed the reason for this communication was not to make a personal profit, but for this joint venture to go through, since the polymer and resin industry were not doing so well. If this joint venture did not take place, the company would have struggled to prosper. And the idea behind asking Mr. I.P. Kedia to purchase the shares of the company was in the company's best interest and also in the interest of its shareholders and employees. Even if there was a profit to be made when IP Kedia sold the shares to Bayer, for Bayer's shareholding, of course, to reach that 51% in ABS, what the SAT observed was that this profit was incidental to the betterment of ABS India Limited. It could not be said that Rakesh Agarwal had violated the prohibition on insider trading, as if insider trading was an offense. He was not found guilty of insider trading under Section 24. So, with this, I now hand it over to the keynote speaker for taking the discussion forward.
Good morning, everyone. Thanks, Jindal Global Law School, Divyangana, Actus Legal, and of course, everyone who's here. Sunday, 10 a.m. is a daunting time for anyone to make it to any lecture. And I really doubt whether I would have been able to do that as a student myself. So thanks, everyone, for being here. The topic that Divyangana chose for me to speak on is quite interesting. Not for me particularly because it deals with the offense of insider trading. I don't profess to be a great expert on the topic, but because it entails an exercise which I think is very important to undertake jurisprudentially for any practitioner of law. And that is an investigation into whether an offense is a civil offense or a criminal offense. And I would start by entering a caveat that this is with the limited perspective that I'll approach the offense of insider trading. It will serve as a backdrop against which we visit some of these principles and theories. And the idea is that this will possibly help you in undertaking a similar exercise for other offenses or crimes or provisions as well. Now, since it's a lecture by a practitioner, I think the first question that becomes very important for us to answer is, why do we undertake such an exercise? What do we gain by pinning a label to a particular provision? What's this obsession with saying, is it civil or criminal? How does it help me? So I'll just start with a hypothetical case. Just keep it at the back of your head. Suppose a client comes to you on a Sunday 10 a.m. and says that, look, I've been served with a SEBI notice and they want me to answer an allegation into insider trading. And the information came to me accidentally. I didn't solicit it. I didn't even know that it was sitting in my email inbox. I accidentally or coincidentally executed a trade, not relying on this information. And I didn't cheat anyone because the volume was low and I actually ended up making a loss. So in your notepad, when you're hearing your clients, you make a small note, no motive, no cheating, so on and so forth. But then immediately there are lots of things that you need to consider, which in my view start with the determination in your head as to whether you're dealing with a civil or a criminal offense. So let me now start with sharing a slide that I prepared last night. Is it there on the screen?
Yes, definitely,
Okay,
Ayush. We can.
okay, okay. So let's start now. Immediately when this comes, sorry, yeah, a lot of aspects come into play because of this determination, and some of them the Divyangana has touched on already, but I'll try to list them. First is mens rea. It's only applicable if it's a criminal offense. For a civil offense, of course, intention is not always necessary. Then is burden of proof, as again the Divyangana mentioned. For a criminal case, the burden of proof is much higher. It's beyond reasonable doubt. Even interpretation in criminal statutes, we say they have to be strictly interpreted in favor of the accused. So that important safeguard is also not available in a civil offense. You have Article 20 rights, such as right against self incrimination, right against double jeopardy, which only apply for criminal offenses. There is a certain amount of procedural strictness that comes into play when it's a criminal offense. You have more safeguards procedurally, cross examination, nature of evidence. And of course, this question can also arise in a miscellaneous matter. I've just cited the instance of Mopi Mohan Raj, where the Supreme Court undertook the exercise of determining whether a check dishonor case is a civil case or a criminal case because another statute called the Insolvency Act required the court to determine this question because it was argued that it was only civil offenses that were prohibited under the insolvency code from proceeding. So these questions can arise in an incidental manner also. But these are, again, very important factors that you need to know when you're arguing a case before your client. You need to know whether intention is required, what is the burden of proof, what is the interpretation tools that I have, what are the procedures that will be followed. And you cannot possibly argue your client's insider trading case till the time you're clear on these aspects. Before you go to court, you need to know where you stand on these aspects. Now, let's start with the basics. So if I'm the person to whom the client has come, and I know that this determination is important for the reasons that I've indicated in the previous slide. Now, let's start with the basics. I've consulted some in the jurisprudence, but I would suggest that you consider any good book to figure out what is a civil offense, what is a criminal offense. Now, I've just listed the main ingredients on this slide. Crimes, as we know, are public wrongs in the sense they affect the entire community. They are prosecuted by the state or an arm of the state as opposed to an individual. And they levy some punishment for deterrence. It could be a fine, it could be a penalty, it could be imprisonment. Civil wrongs are different in the sense that it is the individual who's aggrieved that goes to court saying, I have a right against person X. He's violated that right. So I've come to you and you please give me some compensatory relief. And that's why it's very different from a criminal wrong because there's that personal element to it. I am identifying myself as the person who's been wronged. I claim a right and I seek compensation. Of course, what is very important for this lecture is for you to remember that an act can be both, as is insider trading. So I have chosen the example of defamation, something that everyone recognizes. It's an act that is a civil offense, has a civil provision under torts, but it's also a criminal offense under the Indian Penal Code. So there's no prohibition as such that we have to only have one label for a particular act. It depends. Now, I've again also looked at definitions because as a lawyer, you then pick up some nice dictionary, say a Black's Law dictionary or some other Indian dictionary, and you try and see the definitions. And I found that a penal law is defined to be under at least the Black's Law dictionary to be a penal statute is a law that defines an offense, that's one, and it prescribes a corresponding deterrence for such offense, which could be a fine, penalty, or imprisonment. What is a penalty? A penalty, in simple terms, is a liability imposed as a punishment to a party that's committing a breach. In fact, if you notice the penalty, the word itself subsumes the word penal. So it would, to a lot of people, seem that penalty by itself, if you're imposing a penalty by itself, seems to suggest that we're in the criminal law category. And what we're doing is deterring someone from committing a public wrong. Of course, the picture is slightly different, and we'll come to that later. As Divyangana said, now there are judgments that say that penalty has various hues, various colors, and we'll come to that. But this is the basics, and this is where I'll start with as a lawyer. I'll just see what are criminal wrongs, what are civil wrongs, what are the definitions. Now, I've also just put for your benefit an early view that the Supreme Court had taken on this issue. And this is a judgment by a three-judge bench in Hindustan Steel, and it's a paragraph worth reading. It says an order imposing a penalty for failure to carry out a statutory obligation is the result of a quasi-criminal proceeding, and penalty will not ordinarily be imposed unless the party obliged either acted deliberately in defiance of law or was guilty of contumacious or dishonest or acted in conscious disregard of its obligation. Penalty will not be imposed merely because it is lawful to do so. So, what the Supreme Court seems to be saying here is two, three things. First, of course, that what if a penalty is prescribed for a statutory obligation, we're looking at a quasi-criminal proceeding. Second, it's saying that mens rea will be important because it recognizes that it will not be imposed unless you acted deliberately in defiance of law. And of course, then the corollary is that you cannot impose a penalty merely because it is lawful to do so. This is the early view. Now it's been changed. We'll come to that. Now, applying these basics that we just spoke of, according to me, insider trading checks all the boxes in the sense that there is an act, the SEBI Act, which prescribes the offense. It is, of course, a public wrong in the sense that we're looking at cheating the public, particularly a group of investors, because we don't need special knowledge of the offense in this lecture. But as Divyangana pointed out, that someone has used privileged information to make a profit. So it's not a particular investor, but the public at large, the investors at large, and of course, the integrity of the financial market that is at stake. The idea is, of course, not to compensate a specific individual as we see in civil cases. And the action is not brought by an individual, but by SEBI. So if I look at it from a jurisprudential point of view, just considering the basics, it seems insider trading is certainly a criminal offense. It's a crime. But then, as a lawyer, I open the act and I see what are the textual provisions, what do the textual provisions say? And I find that the act itself at least seems to clearly be of the view that it is a civil provision, it's a civil offense. Why do I say so? I've just listed some of the provisions. And it's, of course, important that as a lawyer, before you go to any case law, you first must read the act and see what is it that the act is saying about this issue. Section 15G, which is the section that prescribes the offense of insider trading, ends with saying there shall be liable to a penalty. So when it uses the word shall be liable to a penalty, it seems to be suggesting the moment the criteria is met, penalty automatically follows. There is nothing else for you to see. Intention and everything else is not material. Section 15I prescribes a casual adjudication process by an adjudicating officer appointed by SEBI. We're not looking at a tedious long criminal trial with all the procedural safeguards that are in place. 15J is the provision which guides the adjudicating officer regarding the penalty to be imposed. It lists three factors, such as whether it's a repetitive offender that you have before you, whether what's the extent of the gain made and what's the extent of the loss caused. But again, in 15J, when the adjudicating officer is deciding the quantum of penalty, motive and intention is missing from his consideration. 15JB is a provision that provides for settlement of some of these cases, including insider trading. And it's titled as Settlement of Administrative and Civil Proceedings. So it's very clear that SEBI thinks what you're settling are administrative and civil proceedings under this provision. 15Y is again a provision prohibiting a civil court from exercising jurisdiction in respect of matters under this act. So again, gives us a hint that what is considered under this part is a civil offense. And finally, the 2015 insider trading regulations. And these regulations are remarkable for the reason that I find they have legislative notes so that you can, while when you read the provision and you have a guidance note also in those regulations giving you a flavor or an idea about the intention of the draftsman. And there's a legislative note to Regulation 4, which also clearly says that mens rea or motive is not going to be a relevant factor when we're considering whether there's an offense under the regulations or not. So the act seems to completely contradict what what the conclusion that we rather reached when we went to the basics. Now, how do we reconcile or how do we explain this? Now I come to the civil obligations theory. Now, what is this theory? This is something, as I come to the next slide, something that is now well accepted by the Supreme Court. And what this theory says is that, look, if proceedings are adjudicatory in nature, the adjudicating officer under SEBI deciding the offense of insider trading, the adjudicating officers are not judges of criminal codes, but are rather part of the administrative machinery. They're not trying you, they don't put you on a trial, but of course they follow some principles, they ask for your reply and they decide the issue. Then what you're looking at is a penalty which is imposed for breach of a civil obligation. And what we're targeting is only delinquency and not motive or intention as such. So what this theory says is that even if penalty is prescribed for violation of a statutory duty, if we find there a summary procedure undertaken by an adjudicating officer, not a criminal judge, then penalty imposed is penalty for a civil provision. Now, according to me, this whole doctrine, which is the crux of the issue, really, is the outcome of certain compulsions of policy. I'll come to that in the last slide. But this is what the theory is, and this is what has been now widely accepted by the Supreme Court, that whenever we find a statute prescribing some offense, even if penalty is imposed, even if it's not a private individual who goes to court, it will still be a civil provision because of the factors that I just indicated. And I've listed some judgments all the way from 1996 till 2020, where this theory has been applied and followed by the Supreme Court, saying all provisions, whether it be under FERA, Competition Act, other crimes, other financial crimes, are civil provisions. And even if penalty is imposed, that doesn't take away from the nature of being a civil provision. And in effect, the first judgment of 1969 that I read out to you, the 3-judge bench judgment in Hindustan Steel, has been discarded. The view initially taken by the Supreme Court that even a statutory provision is inflicting a penalty, it's a quasi-criminal proceeding, intention is important, is something that has today been completely, should I say, discarded or consigned to history. Now, this theory has, of course, led the Supreme Court to also pronounce on the SEBI Act. And I've indicated 3 judgments, which now, using this theory, have clearly indicated that what we're looking at 15G Part 6A is a civil liability. Sriram Mutual Fund clearly says that mens rea is no longer required. Scheme of SEBI Act is clear. Chapter 6A, which also includes insider trading, does not deal with criminal offenses. It deals with statutory civil obligations. So this is a direct application of the civil obligation theory that I just discussed. There is Swedish match, which says that even if the statute may invite a penalty, that will not require us to construe it strictly in favor of the accused like we do in criminal cases. And finally, we have Kishore Ajmera, which says that the test is preponderance of probabilities under the SEBI Act. Only Section 24, which we'll consider later, requires proof beyond reasonable doubt. So applying this theory, or as an offshoot of this theory, we have the Supreme Court saying, don't look at mens rea when you're considering the offense of insider trading or any offense under section chapter 6A. Don't go for the principle of strict interpretation. And the burden of proof you have to apply is preponderance of probabilities. Now, section 24, of course, is very easy. So far, what we were considering was section 15G and the provisions under chapter 6A. And we found that although our basics instruct us one way, but the actual position in terms of the text of the act and the judgments of the Supreme Court suggests the other, the contrary position, that it's a civil provision. Now, coming to section 24 of the SEBI Act, it's fairly clear that these are criminal proceedings. They provide for imprisonment. They clearly say that only SEBI can take cognizance, or in the sense, only, the courts can only take cognizance if the complaint is moved by SEBI. They equate the special court, which is to try this offense, as a court of sessions, and the person who is going to handle the prosecution is treated as a public prosecutor. And of course, there are judgments of the Supreme Court, including the ones that I discussed earlier, Swedish Match and Kishore Ajmera, which also clarified that section 24 is certainly a criminal proceeding. Now, why is it that we have two provisions dealing with insider trading in the SEBI Act? And what is the rationale? Why is this scheme being adopted? As Divyangana pointed out, since 1969, the Hindustan Steel judgment, we've had a number of statutes dealing with all kinds of matters, financial crimes, other obligations. And it's not today practical for you to put every person through the rigmarole of a criminal trial. It is a lot of burden on the administrative machinery of that concerned regulator to match or prove intention, to prove the burden of proof, to basically then secure a punishment for the accused. So they opt for an easier route, which is to classify this as a civil proceeding and extricate themselves from the liabilities of a criminal trial. So I think that the shift that we've seen from the Hindustan Steel to the civil statutory liability theory is to a large extent driven by policy considerations. Civil statutory theory initially only applied to the taxation regime, because for tax matters, you prescribe a penalty if someone doesn't pay tax, but you can't go after every assessee in a criminal trial. But now we find it's a settled principle accepted for other arenas as well, including insider trading. Now, so what you do is you have a civil liability, which is easier. Your adjudicating officer comes into the picture, doesn't consider mens rea, has an easier standard of proof provision, and pronounces his verdict. For more egregious, blatant cases, you resort to section 24, which is your criminal proceedings. And you take a call, and you now will see that I came across recent news articles where SEBI is demanding discretion, to say that we must be given discretion to see which cases to take to the criminal court. Otherwise, we are being accused of being very arbitrary in these choices. So they realize, and if you look at the SEBI annual reports, you'll find, they release annual reports, and I went through the 1819, 1920 reports, and I find that as compared to civil prosecutions under 15G, the prosecutions under Section 24 are more or less negligible. That is for the reason that, of course, SEBI has to go to a special court. The trial is problematic, and it's difficult to get a conviction. Even the prosecutions that are launched under 24 are for failure to pay a penalty imposed under SEBI. So very rarely is Section 24 being used, and the bulk of the work to discourage insider trading is being undertaken through the 15G route, using the benefit given by the Supreme Court and treating it as a civil proceeding. So this is basically this is how I'm concluding my analysis of insider trading. Coming back to the hypothetical situation that I gave you, you now will, armed with all this, you will go to court. You'll know that what you're dealing with is a civil provision, so you won't have a lot of benefits. But what you can do, and this is the last point, is, and I've noted this in the slide, is there is a recent judgment because the Supreme Court realized that we're making it very onerous now with for an accused, because he doesn't have those safeguards. So in Bhavesh Pabari in 2019, what they said is, even though we'll hold you guilty of an offense, but through the back door, when the adjudicating officer is considering the quantum of penalty, he will not be confined to the criteria indicated in Section 15J. He will be able to look at other factors also and impose a penalty lower than the minimum penalty. So even if we hold you guilty, if there are mitigating circumstances in your case, such as ours, where the client did not have the motive, or the trade did not fetch a profit, it was low volume trade, then probably using Bhavesh Pabari, we will be able to secure a lesser quantum of penalty for our client. So yes, I think I've taken up slightly more than 20 minutes, but we can have the questions now.
Yes, thank you so much for that. Thank you for a wonderful session. It has added a flavor of the practical aspect of the law, making the session even more interesting and engaging. And I now open the session for questions. The questions can be asked either through the chat box, or someone can unmute themselves and ask the question. All right, so we've got a comment from Rehan. And Rehan is saying, thank you, sir. This was a great analysis, both from the jurisprudential and practical point of view. Thank you so much for that, Rehan. And any question?
Also, sorry, in case anyone is, if Divyangana, you suggest, I'll email the presentation to you in case any of the students or anyone else wants to make a note of some of the judgments that I've cited.
Yes, definitely. In fact, insider trading is a part of the syllabus in company law 2 this semester.
Right.
So I'm sure we'll have some very eager students willing to and wishing to learn more about this subject. Okay, so we've got Venkatesh here.
Right. Okay. Yes. So again, I would encourage that we confine the questions to the particular angle that we explored, civil or criminal. But Venkatesh has a question on a particular aspect of insider trading, as to why officials of a stock exchange or clearinghouse are not considered as insiders, but officials of ROCR. I'm not very sure of this position. I'll check it. But what I would like to point out is that under the regulations now, an insider is anyone who possesses sensitive information. So the moment you have that information, whether you are connected to the company or not, is immaterial. The moment you have that information, even no relation to the company, but I find someone accidentally sending some confidential information to my email inbox, and I coincidentally, as I said, I intend to take a trade, I am an insider who's accused of the offense. What this list gives you under the regulations are certain people who will be deemed to be connected persons. But it is a rebuttable presumption, as Divyangana also pointed out. So we don't need to be too distracted by the persons they list or not. I frankly don't know the reason as to why certain people have been left out. But to me, that would not be important because you're, as I said, an insider the moment you have information. And it is then for you to say or rebut the presumption. That's how the regulations are structured. And that's just another piece of thought that I like to share, which I couldn't cover in the slide. You see the definition of the provision under 15G says you have to make the trade on the basis of the confidential information. So it demands that you must be motivated by the information in your possession. Whereas the regulations turn the offense on its head and say motive is not important. If you have information, have you undertaken the trade, even if there's no relation between the two, we will presume you're guilty. So another thing someone can explore is it possible for the 15 regulations to upturn the inbuilt mens rea in the Act 15G? Yes. Is profit necessary to prove insider trading? If you go by the explanatory note to section regulation 4, not at all. And that's the problem we're looking at. Even if you make a loss, you're guilty. Your motives, your intentions are not necessary, although you're very right, Arpan, that what we're looking at, what our motive was when we came up with this offense is that let not anyone secretly profit from privileged information in his possession. Because if I use that information to make a profit for myself, I'm cheating the investor body, I'm cheating the stock market. But today, because of administrative exigencies, policy considerations, and in our bid to make prosecution as streamlined and simple as possible, we're completely losing the sight of these fundamentals. And you rightly pointed out, so today, no motive, not relying on confidential, sensitive information, no profit, I'm still looking at a conviction under the Act.
All right, any other questions? And I'll just add to what Aayush had to say, and in light of the questions, I think that in this particular area, there is a fair bit of clarity that is required, particularly with respect to Section 15G qua Section 24.
I'll just to add to what Divyangana said, actually, it's another interesting issue that Supreme Court, when dealing with 15G, says, okay, you don't need high standard of proof, you don't need mens rea. That is all for Section 24. Because they were dealing with a 15G offense or a Chapter 6A offense. So it suited the Supreme Court, if I may say, to lower the standard, help SEBI, and say all this we look at a Section 24 proceeding, because Section 24 proceedings hardly ever come up to the Supreme Court. But the issue is that now the Supreme Court, having held while dealing with the Chapter 6A offense that mens rea and proof are relevant for a Section 24, how do you automatically implant those requirements in a Section 24 proceeding when the definition of the offense remains the same? So when Section 24 is brought for contravention of the regulations don't make mens rea important. But the Supreme Court at the same time is saying we will probably read mens rea into it. So what I'm trying to say, you've not defined the offense separately for Section 24. We're looking at the same definition, the same requirements, but suddenly the Supreme Court wants us to read certain requirements, which are not to be found in the text. And this is because, according to me, Section 24 has received very negligible attention, as Divyangana pointed out. We've hardly had any cases. So the difficult questions have for now been kept with Section 24, and we will sooner or later, as she very correctly says, have to grapple with these issues also, because the offense and the regulations remain the same.
Yes, absolutely right. And we do have cases of insider trading coming quite often, but what we see is that SEBI prefers the Section 15G, Section 15I route as compared with the Section 24 route. Okay, we've got Sanjana here saying something. So Sanjana is saying,
Yes.
if mens rea is not a part of the threshold, then how exactly do offences come under Section 24?
So this is again a very interesting question, Sanjana. Now, having established that at least for a 15G, we don't need mens rea, and we have the Supreme Court telling us that. How does mens rea come into the picture for Section 24? If we look at it fundamentally, we would like mens rea to be a part of Section 24 because no jurist or anyone with a conception of justice would like to send anyone behind bars without first satisfying himself or herself that he was intentionally doing that. So it's important from a point of view of justice, no matter how you conceive it, to read mens rea into Section 24. But then, as I said, the provision is the same. We still have the 15G provision and the regulations, which will be considered by the criminal court, the special court. And they do not seem to, as such, prescribe mens rea, although 15G does to a limited extent. As I said, they say on the basis of confidential information, you must have made the trade. But what will happen is that we'll have to probably read that requirement into Section 24 judicially, even if it's not there legislatively. And this is a question that I expect would reach the apex court sooner or later. But and Divyangana pointed out to the judgment of the Supreme Court in Hans Mayer George. You know, that's something that we studied in CLC together. It was part of our case compilation that was given to us. And it says that, look, if it's a criminal offense, we will presume mens rea is there unless the text completely negates such a presumption.
All right. So I think we've run out of time, and I wish we could have Ayush for some more time with us. It was a wonderful session with him, and now we have to draw it to a close, unfortunately. So thank you so much, Ayush, for giving us your time, especially on a Sunday. And looking forward to many more sessions with you.
Absolutely.
We'll bring this session to a close now. Thank you, everyone. Thank you for joining us.
Thank you. Thanks everyone for turning up on a Sunday.